Jeff Hampton with the Hampton Law Firm. Welcome to our YouTube channel. Today I want to cover 5 strategies to help you beat your Texas drug possession charge. And we're going to jump right into this, but if you wait around to the end of this video, I'm also going to give you a free ebook, How to Beat a Drug Charge in Texas. All right? Now, let's jump right into this. What are our strategies if maybe you're facing a Texas drug possession charge and you're trying to figure out how to go about this? You know, one of the questions that's brought up to me all the time is people say, well, Jeff, I don't get it. The rest of the country seems to be moving forward with legalization, especially as it relates to marijuana. And what about this long list of other drug charges that are out there? I've heard stories that Texas is pretty hard on those. Are there ways to actually be able to beat those charges? And by the way, when people call me about drug charges, they have really a couple of priorities in mind. Number one, they don't want to go to jail. Number 2, they want to not be a convicted felon or have a conviction on their record. And number 3, they want to be able to clear all of this off of their record. Not only the police reports and the charge, but the arrest itself. So we're going to talk a little bit about some ways that you could potentially do that here today. All right, so number 1, what are some of the common defense strategies that you might be able to use? Well, one of those is that you just did not possess the drugs. Now, I want to dispel something for a second. Some people will call me and say, well, Jeff, they were not my drugs. So if you can prove, can I prove to you that because they're not my drugs, then that means the whole case should be dismissed? Please understand, drug possession does not require proof of ownership. It only requires that the state of Texas prove that you exercise care, custody, or control over those drugs, okay? So they may not be your drugs, but if they know that if you express some sort of knowledge that you are aware that those drugs are in that car, or that you're near those drugs, or maybe you were holding those drugs for someone else, the law doesn't make a distinction on ownership. The law makes a distinction on intentionally or knowingly exercising control, okay? That's the key. However, what if you are in a car with someone? What if they find drugs in the center console? You're a passenger. There's someone that's driving the vehicle. How are they going to prove intent? So even if you're there and maybe you did not intentionally possess the drugs, the state of Texas is going to have to prove that you had intent to do so. Failure to do that, failure to be able to show that, they will not have a good case against you. So number 1, the state of Texas may not be able to prove that you intentionally or knowingly possessed those drugs, okay? That's the number 1 defense. Number 2, and I bring this up because it is viable, it happens rarely, but it does take place, is the defense of entrapment. Entrapment. Now, why do we bring that up? Because sometimes there have actually been stories of police officers and law enforcement, particularly narcotics, that have planted drugs on people. There was a situation that happened in Baltimore back in 2017 that took place where they caught police officers doing this. But in this situation, when we talk about entrapment, it's not enough that an officer lied to you about something. If a police officer coerced you into purchasing or holding drugs, and then they use that as a basis to make an arrest or charge you with drug possession, that's where we get into this. When we talk about entrapment, this is when an officer does something that coerces or puts you under duress, that you make a decision that you would not have done on your own, okay? So it's something that's kind of really pushing you into a corner to commit a crime. So I want you to understand, when we talk about the defense of entrapment, please remember, a law enforcement officer lying to you is not considered entrapment. Police officers, believe it or not, the Supreme Court has ruled that police officers, undercover or not, can still lie to you, and as part of that lying process, as long as that lie did not coerce or put you under a position of duress to commit that crime, then that is not seen as entrapment, okay? Now, number 3 is unlawful search and seizure. Now, this is especially relevant when it comes to someone pulling you over if you're driving a vehicle, or coming to a residence or to a location and finding drugs. So let's talk first, number 1, about being pulled over in a vehicle. So the police officer must have reasonable suspicion to stop you. Okay, if the police officer has no reason to stop you, if you're not committing a traffic violation, if there's not something that's substantial there for them to hold on to, then that's an illegal stop. If it's an illegal stop, then anything the officer finds, even if he walks up and finds all kinds of drugs sitting in the car, at that point it would be illegal, and everything that comes after that is not admissible in court. So number one, you want to make sure, was there a lawful stop that took place? But what if you're at your home or at a building? What if a police officer shows up and they would just barge in and wanting to search a location? Is that permissible? No. Generally, if an officer wants to come in and search a location, they're going to have a warrant. And the way to attack a warrant is you need to look and see not just the warrant, but the affidavit that accompanies that warrant. In that affidavit, there should be specific facts that will articulate enough evidence to substantiate a search. And quite frankly, sometimes we will find search warrants that are sparse. They just don't have very many really true facts. They may have some conclusory statements, but maybe there's no real evidence to back up the basis for the actual search warrant. If that's the case, an invalid search warrant invalidates any arrest and any potential charge that could come against you, okay? So those are a few things to know there. Now, one of the things that we look into, let's move on to let's move on to our next point. What if we're talking about now there is a valid charge? What if it looks like all the basis for everything is substantiated in terms of your possession, the arrest, all of those things? Well, one of the other things for you to consider is a diversion program. Okay, so this is the reason why I say that is if you're a first-time offense, if maybe you've never been arrested for a drug possession charge, the great thing about some of these diversion programs is you can get into a potential diversion program even with a fairly large amount of illegal drugs. So you may immediately think, well, there's no way I can get into one. Well, this is why it's so important in the decision that you make as to who you hire as an attorney. I have a whole separate series of videos that talks about diversion programs and some of the deadlines and some of the requirements on it. The number one rule you need to realize is there is a 90-day program for most of those diversion programs, particularly in Tarrant County. There may be some separate rules for some of the surrounding counties, but do not just assume that you cannot be eligible for that type of program. That is something that needs to be examined by your lawyer before you miss out on that, okay? And finally, one of the last things we're going to talk about here is, and it's rare, but I have represented several people who had medical marijuana. And one of the things I want you to realize is whether it's from another state, maybe you have a medical marijuana card from another state. Now, that card doesn't necessarily transfer over as a legal defense in Texas. However, it does show that you had a legal reason to possess that in a separate state. And we have been able to negotiate conditional dismissals for clients who have had a medical marijuana card from another state. But what if you qualify for the actual medical marijuana exception in Texas? There is something called the Texas Compassionate Use Act, and it does allow a small group of people that qualify for it to be able to use marijuana medicinally. And so it's a very exclusive type thing. You probably know if you have it or you don't. But most officers, if you qualify for this, are not going to listen to you when you tell them that you qualify and that you have an actual legal basis for it. They'll arrest you first. And then you have to come back later and you have to defend it. So if you may happen to qualify for that and you have one of those exceptions, epilepsy, there's certain types of listed medical conditions that qualify for the Compassionate Use Act under the Texas law. If that applies to you, we can get your case dismissed. So my point is there's many different ways that a Texas drug charge may be able to be defended. And it's very important that each and every one of these strategies is looked at thoroughly so that way you get the very best result on your case. So if you have any questions, don't hesitate to contact the Hampton Law Firm at 817-877-5200. We offer free case analysis and free case evaluations, and we would be happy to talk to you and answer your questions. By the way, I promised you if you waited around till the end of this video, I would give you a free ebook, How to Beat a Drug Charge in Texas. All you have to do is click the link below and input your email information, and we will be happy to send over that information straight over to you. Thanks again for joining us on our video series. We look forward to seeing you on our next one.